Hello everyone, I'm Debojit Das here to welcome you to another episode of Courts Today by LiveLaw, ready with today's top legal headlines. So let's begin. Starting with an update from the ongoing detention of Ladakh's Sonam Wangchuk under the National Security Act or NSA, which has been challenged in the Supreme Court by his wife Gitanjali Angmo. The core of her argument today too was procedural illegality. Ms. Angmo asserts that the detention is unsustainable because it relies heavily on stale FIRs, some dating back over a year and mostly not even naming Mr. Wangchuk, meaning they lack a clear live connection to the current detention. Crucially, she argued that the complete grounds for detention were not supplied within the statutory limit. Though the detention order mentioned 4 videos, Mr. Wangchuk was only given access to them 28 days later, just before the advisory board meeting. This, she contends, is a flagrant violation of the NSA's procedural safeguards, depriving him of the opportunity to make an effective representation against his detention. In short, the challenge is not just political, but a sharp legal attack on whether the government strictly followed the law when detaining a high-profile activist. The Supreme Court has allowed the amendment application and will hear the union's response to these additional grounds. Next, in an important ruling, the Supreme Court provided clarification regarding the necessary standard of proof in corruption cases under the Prevention of Corruption Act 1988. The core principles at play here, as clarified by Justices P.K. Mishra and Joy Malia Bagchi, is that mere recovery of tainted currency notes is insufficient for conviction without establishing the foundational facts. Specifically, for an offence under Section 7, taking illegal gratification, the prosecution must prove both the demand and the acceptance of the bribe beyond a reasonable doubt. Only once these foundational facts are proven does the statutory presumption under Section 20 of the Prevention of Corruption Act, which shifts the burden of proof to the accused, even arise. In this specific case involving a former assistant labor commissioner, the court acquitted the accused, finding the complainant's sole testimony regarding the demand was uncorroborated and unreliable. The ruling powerfully reaffirms that finding money near a public servant does not automatically equate to corruption. The crucial elements of demand and voluntary acceptance must be definitively proven. Staying with the Supreme Court for this one, as the court reportedly batted for expanding the boundaries of employees' compensation law. In this case, an insurance company challenged compensation awarded to the major widowed sisters of a deceased worker, arguing they did not qualify as dependents under the Employees' Compensation Act of 1923. The court, while ultimately upholding the compensation, acknowledged the problem with the Act's Section 2, subsection 1, clause D. This provision defines dependent to include a widowed sister if a minor, effectively excluding adult widowed sisters. The bench, comprised of Justices Rajesh Bindal and Manmohan, pointed out this literal interpretation is archaic or old-fashioned, especially considering modern laws like the Hindu Marriage Act. The Supreme Court did not judicially amend the law, but instead took the professional step of recommending the Union government refer the matter to the Law Commission of India for a suitable amendment. The goal is clear: ensure the law reflects current societal realities where an adult widowed sister is often financially reliant on her deceased brother. Moving away from the Supreme Court now and taking a look at this Odisha High Court ruling that offers a candid look at judicial integrity, where a judge admitted to a mistake of fact and recalled their own judgment to prevent a miscarriage of justice. The case involved a petitioner seeking a green card based on a tubectomy procedure performed in 1998. The original writ petition was dismissed by Justice Shashikant Mishra primarily because the claim was deemed stale, having been filed after an alleged 27-year delay. However, in a review petition, the court realized a critical mistake. There was no statutory limitation period mentioned in the relevant government resolutions for claiming the green card. By focusing solely on the time lapse, the court inadvertently dismissed the case on an accurate factual premise, the mistaken belief that the claim was barred by delay. Justice Mishra promptly recalled the dismissal, stating that no one should suffer because of the court, ensuring the case could be heard on its merits, especially since the key documentation was damaged in the 1999 super cyclone. This highlights the importance of the judiciary's power to review and correct its own errors. Moving on, and news agency ANI once again found itself in the news, receiving a sharp rebuke from the Delhi High Court over its conduct in a copyright dispute with Dynamite News. So here is the core of the dispute. The two parties were in litigation, and after a partial settlement, a single judge directed the Dynamite News' YouTube channel be unblocked. However, ANI then took the law into its own hands. Instead of going back to the court, the news agency bypassed judicial procedure and went directly to YouTube with a fresh list of video links. This private action successfully led to the competitor's challenge being blocked once more. The bench found this maneuver utterly unacceptable. The High Court emphasized that by not approaching the presiding judge first, especially when the matter was active, ANI was attempting to overreach the court's process, effectively reversing a judicial order through private means. The court decisively deprecated ANI's conduct, calling the attempt to enforce its claims outside the established legal procedure as unjustified. The next important story comes from the Karnataka High Court, which is currently handling a case against Ola Electric CEO Bhavish Aggarwal and others, who are seeking to quash an FIR registered under Section 108 of BNS, that is, abetment of suicide. The FIR was filed after an employee, Arvind, allegedly committed suicide, leaving behind a note citing workplace harassment and denial of salary dues. During arguments, the defense, led by senior advocate MS Shyam Sundar, aggressively questioned the veracity of the suicide note, even suggesting that the complainant, who is the deceased's brother, may have written it, a submission the complainant's counsel called highly inappropriate. The defense also raised a professional concern, noting that the company is a public listed company and arguing that media narratives about a toxic work culture were causing its share prices to drop. They argued the police should have stuck to the initial unnatural death report. Justice Mohammad Nawaz firmly directed that the police must conduct a fair investigation under the complaint, cautioning them not to harass the petitioners. The court allowed the probe to continue but extended its interim order protecting the petitioners from any coercive action. Moving further towards the south, and the Kerala High Court issued a landmark ruling, unequivocally asserting that a husband's unfounded suspicion constitutes serious mental cruelty sufficient to grant a divorce. Overturning a family court's refusal, the division bench, spearheaded by Justice Devan Ramchandran, emphasized that a constant, baseless pattern of toxic suspicion is far from a minor disagreement. The court was presented with the wife's testimony detailing the unbearable atmosphere created by her husband's behavior, which included locking her indoors and monitoring her loyalty. The judges stated that a suspicious husband can turn the matrimonial life into a living hell. They reasoned that marriage is fundamentally built on mutual trust, and when this foundation is systematically poisoned, it severely damages the wife's self-respect and mental peace. This behavior, the High Court concluded, is a profound form of cruelty that deprives the wife of her dignity and freedom, making the continuation of the matrimonial bond impossible. And for our final story, we take a look at this decisive ruling from the Allahabad High Court, which puts a permanent stop to the mixing of education and commerce on school properties across Uttar Pradesh. The case originated from a public interest litigation filed against the use of Brahmanand degree college's premises for organizing a commercial mela. Although the fair was over by the time the PIL was heard, the division bench of Chief Justice Arun Bhansali and Justice Kshitij Shailendra refused to dismiss the core issue. The court held clearly that educational institutions, including their land and playgrounds, are meant for imparting education only. They stressed that the infrastructure must be used strictly for academic, sports, or cultural activities, and for no other commercial purposes such as exhibitions or trade fairs. The judges noted that despite earlier similar court orders, commercial activity was still being permitted, sometimes through administrative clearances by district officials who were unaware of existing legal bar. The High Court not only banned the use of the college playground but directed the state government to issue a clear and unambiguous circular to all educational institutions and administrative authorities to ensure compliance immediately. That's all from our side on courts today, but if you want to access a detailed coverage of all the stories mentioned here, visit livelaw.in and follow us on all our socials to stay updated with everything that is law. I'm Debujit Das. Thank you for watching.